now our vice president in the CCBE. He is also a criminal defense practitioner in Ireland and has been also chair of the CCBE Criminal Law Committee for many years. James, the floor is yours.
Thank you very much, Simone, and thank you, Juan Fernando, for your remarks. The first point, of course, is that the Irish system is not comparable with the Italian system, as you say, but it's neither comparable with the Irish system of last year. I'm speaking to you from a courthouse in Kilkenny, where we're doing a murder trial that would normally be heard in Dublin, and we're here because the courtroom is bigger and can accommodate social distancing. Everyone in the courtroom is masked. Many of the witnesses are giving evidence by a video link because they're cocooning or self-isolating. And I have to say that it is not an entirely unsatisfactory experience. 12 months ago, most of my colleagues would have said that it was absolutely essential that you would confront witnesses in the courtroom, that it was unsatisfactory that the jury weren't sitting beside each other. But we've moved on from that. And the remarks I'm about to make should not be taken as a lawyer simply saying, we have to do it the way it was always done. I'm going to say something about the core values of the CCBE and access to justice. And you mentioned, Juan Fernando, the importance of the principle of legal certainty. Well, if we go back to the Middle Ages and the English Court of Star Chamber, there could be nothing more certain than the outcome of that hearing. It's not the certainty that we need, it's the justice. And when member states talk about efficiency, they're generally talking about cost reduction and time reduction. But justice rushed is very much the same creature as justice denied. And in particular, I want to talk today about the potential for dealing with justice by the use of algorithms. And we have the experience from the United States and the notorious Loomis case in Wisconsin, where the algorithms lead to, in that instance, a prejudiced and racially prejudiced outcomes. So let's go back to first principles. And the first principle, and I noted that you quoted from the Charter, and the Charter obviously incorporates the Convention, are what are the fair trial rights guaranteed by Article 6. And those fair trial rights are that in the determination of his civil rights and obligations, or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. And it continues in Article 6.3d, and to examine or have examined witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. And that's the key to it. That is to have a decision-making process that is transparent, that you can understand how a decision was arrived at and why. It's not an unusual case in criminal proceedings that you might have 4 witnesses saying precisely the same thing and 1 witness saying something entirely different. The algorithm might say to you that 4 must be right and 1 must be wrong. But in a courtroom with an experienced judge or jury, being skeptical, they may realize that 4 people have come together to tell a lie, and that the one person is supported by other corroborative evidence. We learned many years ago now of the critically valuable role that DNA evidence plays in criminal trials, both in proving guilt and also in establishing innocence. But we have also learned that the technology is not flawless, and we have a much better understanding of cross-contamination and the dangers of false positives. And that becomes even more compounded when member states under-resource their forensic laboratories. And now we're coming across lots of cases where the science is dubious. So we should have to be skeptical about the artificial intelligence. Now, we've identified a number of potential dangers with the artificial intelligence improperly used, and there are lots of benefits when it's properly used. The first is that the use of data and elements that have not been subject to independent scrutiny by each party. And in terms, that effectively means that a judge could be giving evidence to himself in secret. They check something on their algorithm. The parties don't know what they've checked. They don't know if they know how to use it properly. They don't know what the issues the parties would have raised in relation to potential unreliability or bias. And unfortunately, algorithms are precisely that. They make mistakes. Every one of us has critical texts on our mobile phones, and every one of us has sent messages we didn't intend to send because the algorithm wrongly assumed what we were trying to communicate. So the first-hand experience of artificial intelligence means that you must know what's going on so that you can scrutinize it. That leads on to a further challenge that we see, which is the impermissible delegation of decision-making. The reason we train and appoint independent, experienced judges is to get the benefit of that wisdom, not for them to delegate it to an algorithm and to fail to exercise their normal experience of life and the scrutiny that should be applied. We would be concerned that the use of artificial intelligence would be more readily available to law enforcement than it would be to the defence. And then to that extent, there wouldn't be equality of arms. But I would also freely concede that access to quality information, decided cases all over the other jurisdictions, the sorts of things that we can get with the benefit of technology, also means that the David and Goliath situation can arise. A small practitioner with the same technology as the huge police force can achieve great results. So I'm not saying that this isn't a two-way point. We have seen throughout COVID-19 the errors that have arisen in all of our jurisdictions in profiling. And these are experts. So an algorithm that will try to predict the commission of crime into the future is effectively, a tool for preventative detention, which is anathema to practicing lawyers. Then what do we do about this? And we've identified 4 possible safeguards that might be used so that in any case it should be possible within the judicial decision to identify the element. So that leaves open the opportunity of questioning, challenging, or appealing. The principle of non-delegation, the role of AI tools should not be defined in a way that enables.
Yes, sorry, James.
Relating to data collection. Have I lost you?
Yeah, well, there were some connection problems. I think if you could perhaps repeat your last point.
Okay, I was just touching on 4 principles that we have identified in the CCBE safeguards. The principle of identification. In any case, it should be possible within the judicial decision to identify the parts that are AI and the parts that are not. The principle of non-delegation. The judge makes the decision, the AI does not. The principle of transparency, so that it is clear exactly what is going on and that learning software should be available. And it's critical in this context that if we're going to go down the AI route, that the member states must provide resources and training for defence practitioners and not simply for judges and prosecutors, as has been the history in so many measures in the past. And that the parties must have the opportunity of addressing the outcome of AI, which is a simple principle of audi alteram partem. Again, I think I would just conclude by saying that we are not opposed in any ridiculous medieval way to progress, but we have learned, and we all must learn, from the difficulties in the past and the miscarriages of justice. And efficiency can be a byword for processing people who are vulnerable and whose rights are denied them. And it simply looks good on the justice scoreboard because trials all concluded within 6 months. And that, Simone, is not justice.